Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to our Napa Legal Weekly podcast, where we explore religious liberty from the perspective of faith-based nonprofits. We have some interesting cases this week, many of which center around Colorado, which seems to happen often. We'll be covering a Colorado law banning counseling based on Christian viewpoints of sex and gender. Then we'll flip to some updates on school choice, and we'll finish with a policy change by JPMorgan Chase that will hopefully prevent debanking of organizations based on religious faith.
Thanks so much, Frank. And if I may just interject, our first and most important update today is to congratulate the DeVito family on the recent birth of their daughter. So I think that's the most important update we'll have this week. Everything else is pretty much business as usual. So congratulations, Frank.
Well, thank you. Yeah, and so if people are noticing that the time of day is different, there's like light on my shoulder. It's the wrong day to be releasing the podcast. That's because of paternity leave and some shuffling around of the schedule. So thanks for accommodating.
Great, thank you. So back to just general legal updates. We do have an important first story, and as Frank said, the action takes place in Colorado with this first story. So we're looking at the case Chiles versus Salazar. I think a lot of us have wondered what happens when a person experiencing gender dysphoria is seeking treatment and seeking healing and wants to harmonize the disconnect between the person's mind and body. And this question is particularly poignant when the person having the experience of gender dysphoria wants to approach their treatment journey from a faith perspective. So, what options does a person like this have? What options does a counselor have to offer wisdom and professional insight in these circumstances, particularly if the patient has asked for a biblical or spiritual based approach to their therapy? Or if the patient has said, I'm not interested in exploring surgical options, I really want to um, approach this like from a faith perspective. Well, in certain states like Colorado, these patients and these counselors have no options. Surgical intervention is the only option for gender dysphoria. Other treatments, counselors are prohibited from recommending them, from doing faith based therapy or any combination of that. Counselors can't even provide a menu of options. It's of grave concern, particularly for people of faith, especially those who feel called to minister in this area, since in Christ's own ministry on earth, he really focused on those struggling, particularly in areas of identity and living in accordance with the truth of their identity as being made in the image and likeness of God. And yet, people of faith cannot do this ministry in states like Colorado because their laws actually prohibit um, any kind of conversation in this area. It sounds crazy, but the law is quite extreme. So, ADF and a local council in Colorado have challenged this state law, um, asking the Supreme Court to answer the question: Can this be changed for the better? Can counselors' freedom of speech and patients' right to have those conversations be protected? So, in the case Chiles versus Salazar, the Supreme Court will consider this what's called a conversion therapy ban. Um, and from ADF's perspective, this issue poses a number of First Amendment violations, but particularly centered around free speech. And I think this is a really interesting focal point for the case because there are a couple different layers of First Amendment issues and violations going on here. I think there are free exercise violations, potentially freedom of association and assembly, but ADF's really focusing here on free speech, just as they did in the 303 creative case, which successfully protected First Amendment rights. So I think it's kind of interesting if you're focused on religious liberty, why is this not expressly being litigated as a free exercise case? And I think the reason is um, perhaps it's a strategy to try to like approach these issues in a way that in the language of society today. So in our kind of post-Christendom world, religious freedom challenges have often been mischaracterized really as a form of favoritism or Christian nationalism. And maybe highlighting free speech is the best way to start bringing people to the table since there is some consensus around this. It brings the topic back into our current lexicon even though many people in society aren't able to talk about faith or they don't fully understand what it means to live someone's faith or to have religious freedom outside the four walls of a church. Um, Free speech is an area that most people still understand, and so maybe approaching these issues as a first step is a way to open up dialogue around deeper and kind of more and maybe not more fundamental, but at the same time deeply important questions about religious freedom and the full free exercise in today's society. So I think this is a really important case and one that's likely to have a significant impact on the landscape nationally. Patient care, the freedom of Christian ministries and other faith based ministries to do their work in accordance with their faith and share what they understand and what their patients are seeking as the fullness of truth. So I don't know if you have any thoughts on this, Frank, but I would love to hear your perspective and how you think this case could impact these gender issues and these healthcare issues more broadly.
Yeah, we were talking about this before we started recording, but I think there's this kind of scientific consensus narrative problem, and we've had this for a long time. And this is not just like a cultural issue. This is actually going to have legal ramifications and how these cases are decided. So I think it's important to back up a little bit here and say it gets treated, this issue especially of quote unquote conversion therapy, right? Treating people with gender dysphoria in a certain way. It gets characterized often in the mainstream narrative as if this is just settled science, right? Gender dysphoria is a real issue, which is true. And then the only way to help somebody with gender dysphoria is to affirm the perceived gender or the perceived identity of the person experiencing it. That seems to get taken as a truth, as something that's just kind of accepted, and there's no other way around it from a scientific perspective. And that's a huge problem because, well, because it isn't true. And this is not just a religious belief, right? We have religious beliefs about the truth of the human person and about sex and gender and all that. But even that aside, there's not scientific consensus. And this is starting to unravel a little bit in I think more mainstream sources outside of religious circles that convert not conversion therapy, but the typical ways of what is it, like identity exploration, helping a patient gender transition, like these are not having happily ever after outcomes, right? The rates of just failure of people who go through these therapies and they're not okay at the end, right? Suicide rates, regret for gender transition. This is all coming out of the woodwork as a real thing. So my point is, again, I'm not a psychologist, I'm not a scientist on this, but it seems pretty clear that this is not settled science. Um, but that narrative makes a huge difference in how this plays out, right? Because if there's settled science and then Christian conversion therapy is this weird fringe thing that can only be harmful from a scientific perspective, if that's the case, then these kind of laws banning conversion therapy seem to make more sense. But if the science is not settled, right, and we really don't know how to best treat gender dysphoria, then the obvious thing to do is to let psychologists and medical professionals use different types of therapy and see what works, right? Because anecdotally, it seems like there are a lot of people who do um, get good results from things like quote unquote conversion therapy. So again, this is a problem of narrative and culture um, that it's being treated like this, that this is a settled point of science when it's not. But I think just to wrap up here, this affects the legal analysis, right? Because if this is indeed viewpoint-based discrimination, which it is, right? Because one viewpoint is being suppressed and another is not, in the way that you treat the same disorder. So if if the former mainstream narrative, right, that like, well, conversion therapy can only be harmful, it flies in the face of settled science, then the government probably has a compelling interest in preventing this, right? If you get into the strict scrutiny analysis, um, that's going to come out differently. Whereas if this is not settled science, then there's really no basis for viewpoint discrimination in this. So I do think it matters. I think it'll affect the strict scrutiny analysis greatly, how we're talking about this issue and how settled the science actually is.
That's a great point, Frank, and I wanna underline what you just said, like, one of the key facts in this case is that the conversations here are consensual. So it's patients seeking care from a counselor seeking to provide the care they're looking for, and so, um, the law that Colorado has banning these consensual conversations. It's just crazy that it's not supported by science, and it's actually against the desires of the parties involved. So it's quite radical. And I also, just to close off, wanted to read the exact question presented to the court in ADF's cert petition, just so we can get a sense of exactly what to expect from this decision. And that question presented is whether a law that censors certain conversations between counselors and their clients based on viewpoints expressed regulates conduct or violates the free speech clause.
Yeah, this is a really interesting one, and I'm sure we'll be following that as it goes through the Supreme Court and oral arguments take place. And we're going to pivot to another case now that's also pending before the Supreme Court, as well as some state laws that are related to the issue of school choice. So I want to talk about a couple things. First, I want to briefly touch on the St. Isidore, the Oklahoma statewide charter school board versus Drummond case that's now pending in the Supreme Court. And then we're going to talk quickly about a case in, this one's also Colorado, I believe, yes, about a universal preschool program and also a tax credit for private school expenses that was just signed into law in Idaho. So a lot going on here. I'm going to try to kind of put these into buckets, and we'll talk a little bit about where we think the school choice issue is right now in the states, and where we what we think about that and where it's headed. So first, I think just touching on the St. Isidore case itself, I think pretty much anybody who's listening to this has probably come in contact with this case. I think I've discussed it previously on this podcast. But just briefly, this is the continuation of the fight to allow religious schools a place in the government-supported marketplace of educational options for parents, right? So we have this line of cases. We had Carson v. Macon a couple years ago that was touching on a similar issue of excluding religious schools from government programs. That was a little narrower in Carson v. Macon. It was the program for people who lived basically too far away from a public school, and they could get some assistance to attend private schools, but religious schools were excluded. That was found to violate the free exercise clause by excluding schools only because they're religious while allowing all other kinds of private schools, right? So that's the issue that we're centering in on. And then it got a little bit more broad in St. Isidore when we're talking about the actual funding through a charter school program of an overtly religious school, whether that violates the establishment clause. We don't think it does. And whether preventing religious schools from being involved in the charter school system violates the free exercise clause. I think it does. So that's where the St. Isidore case is. And I think if this comes out in a way favorable for St. Isidore, this is going to be a real continuing sea change of religious schools being able to participate in various government funding programs at the state or local level. So it's a big deal. Obviously, we'll be following St. Isidore very closely, and we'll be updating you on that. But in the meantime, at the state level, there are often statutory or trial court level actions about school choice and the role of religious schools, and it's worth following them and not just focusing on the big Supreme Court cases. So, two things. One is a really interesting case concerning I want to get the name right, the Darren Patterson Christian Academy. This is in Colorado. So in this one, there's a universal preschool program in Colorado which provides tuition reimbursements for a parent to send a child to a preferred preschool. And now I think this is going to be a big issue, and we're going to see this in a lot of cases in a lot of states moving forward, and we already have. Right. So the attempt to just exclude religious schools has been treated pretty hostilely, rightly so, by the courts, right? If you have this program that says all private schools can come for funding under this preschool program, except religious schools, you're hitting free exercise problems, right? Courts are actually cracking down and saying, no, you can't exclude, a school because they're religious in the same way you can't just exclude people because they're exercising their faith. Like, this is a free exercise problem. So the next evolution of these attempts to exclude religious schools has been, rather than excluding them on the basis of their religion, requiring schools to adhere to various, non-discrimination provisions regarding sexual orientation and gender identity, or placing things into the contract that says for you to participate in this program, you can't, hire based on religion or faith. So basically what they're doing, it's a workaround, right? It's not the same direct exclusion of religious schools, but it says, if you don't basically toe the secular line on sexual orientation, gender identity, if you insist on building a culture of employment based on a shared faith, then you can't participate. And it's a little trickier this time because it's not an overt religious exclusion. So this is popping up. This is what happened in the Darren Patterson Christian Academy. They were excluded because they have hiring policies and SOGI policies that conflict with the state statute. They were excluded from the preschool program. Lawsuit ensued, and this one did come out favorably, but I don't think it's going to be a sea change kind of ruling. It was pretty narrow. In this case, the court opinion stated that houses of worship can impose special requirements on their congregants irrespective of non-discrimination laws. So in this case, the Darren Patterson Christian Academy was qualified as a house of worship. And so they made it through, but it's kind of a narrow, exemption. So again, I think this one will continue to be a fight to see whether states that are hostile to religious schools taking part in these programs can kind of use non-discrimination requirements as a way to get around this. But we'll see. Again, this is going to go on for years. That's just the reality. States are going to try ways to exclude religious organizations. Good people at places like ADF and Beckett and other places are going to continue to fight with them, and we'll have to continue to carve out precedents and see how much legal protection schools are afforded to take part in these government funded programs. Mary Margaret, did you want to say anything on this part before we touch the vouchers?
Um, I think I see, especially in the St. Isidore's case, but in the Darren Patterson Christian Academy case as well, kind of like two themes. I think one is the history of our country's kind of mischaracterization of the Establishment Clause that I would guess probably began roughly in the progressive era, so like 1920s. But like you've said in past episodes, the Establishment Clause means that there can't be a state church. It does not mean that the government and entities of faith cannot collaborate in a productive way to solve humanitarian and other issues in society. So I'm really relieved to see that house cleaning continue to take place. And I know it probably will require a lot of district court cases like this, these one offs implementing big decisions like Kennedy versus Bremerton and Carson versus Macon. So I think there's kind of that legal side that jurisprudence is really heading in the right direction on a correct, rightly worded understanding of the Establishment Clause. I think it's kind of interesting that there's also a cultural side to these issues because especially when you see like the Colorado preschool program where they say, oh well, religious groups can participate, but basically they have to not be who they are by agreeing to these terms that are contradictory to um, their own identity. And so it's almost like the Establishment Clause misunderstanding led to the cultural perception of faith as being allowed to go to a house of worship on, stand within those four walls on a Sunday or a Saturday or whatever day of the week it is. So it's almost like the law kind of the issues with the understanding of the Establishment Clause harmed the culture, and now the culture is trying to harm the law back inadvertently by having these policies that clearly show a misunderstanding of what it means to be a religious organization. And so it's like the law is back on track. Now we need the culture to kind of recover from this period of time where faith was viewed as like almost some kind of contagion that needed to be like quarantined, like that separation of church and state is like it's almost become like a quarantine dynamic where it's like, well, this program, I mean, I remember one of the most infamous examples in my mind was the FEMA cases where there were churches giving hurricane relief efforts and everyone participating in the hurricane relief program was allowed access to FEMA grants except for the churches. And that was just like I thought so illustrative of the underlying issue, but the laws on the roof is being reformed, but now we need the culture to catch up, and particularly in these examples where, um, yes, religion's being allowed, but now there's just this deep, long-standing misunderstanding of what it even means to be religious that the culture doesn't understand, and that's why I think we're seeing some of these agencies, especially at the state level, enacting these regulations that are that just indicates such a deep misunderstanding of what faith is, you know?
Yeah, no, so many excellent points there. And the one that I'm gonna reiterate it, even though I think I've said it on here before, and make just make the point. You don't have to be a constitutional scholar to understand this, right? Because you're to your point, the Establishment Clause has been misinterpreted and misused for the last probably about 100 years now. And just to be very clear and repetitive on this, the Establishment Clause is meant to prevent governments from establishing one denomination or one sect and favoring that one and at the expense of all others. Like that is what establishment means. Allowing religion to be funded or participate in public life is not an establishment of religion. Period. I just want to put that out there, right? If the Oklahoma Charter School Board was going to allow St. Isidore's Catholic Charter School, but then exclude the Baptist school and the Methodist school and the Jewish school, then you have an establishment problem. But just the fact that a charter school program is going to make contracts with religious schools is per se not an establishment of religion. And I know this is like shocking to a lot of people, but it should not be controversial. It's just very clearly what establishment means. And I'm going to keep saying that every time St. Isidore comes up and in the hope of spreading the word. So one final note on the school choice issue. This is flipping to Idaho. This is an interesting one that is not very controversial, but I think it raises an interesting question. So Idaho recently just passed it's not technically a voucher, it's framed as a tax credit. So the governor just signed a bill that basically allows up to $5,000 in tax credits for private school expenses, transportation, tuition. There's an additional credit available for students with special needs. Strong public support for this bill. It basically allows people, right, to get their tax money back, right? If they're paying in for the public school system, but they don't want to use it and they want to go to a private school, they get a lot of the tax money that they're paying into the school system back to pay for the tuition expenses. Now, I think this is a tough issue, because every time this comes up, the public school, like the teachers' unions and the public school advocates, get really uncomfortable or fired up because you're taking away money that's needed to have a public school system, and it threatens that system if enough people opt out, right? If all of a sudden 40% of the population of a state decide to leave and go take those tax credits, you're going to have a really questionable public school system left, right? Like people aren't funding it, people are going elsewhere. What's going to happen? The reason it's hard is because I think in theory, funding public schools should be a public good that all citizens can get on board with, right? Like my wife and I, we homeschool, so we're not using the services that we're paying many thousands of dollars in taxes for, right? The public school system, but in theory, it makes sense, right? We should have a system that gives a certain base level of education to all of our citizens. That's fine. The problem, and it's a growing problem, is when more and more citizens are not they're not opting out of the public school system because they would just subjectively prefer a private school or a religious school, but because, and especially since the COVID era, more and more people are seeing the public school system as dysfunctional, both as academically not up to standards and also in opposition to religious faith and the ideals and the practices that are being taught to kids in the public school. So this is a real problem because then what we have is this taxpayer funded system that more and more people are questioning whether it's a good thing, right? So these kind of like tax credit or voucher programs, they make sense to give choices, but the reality is if enough people start to see the public school system as a failure and start to take these voucher or these tax credits, I think we're going to have a real problem with the public school system being seen as a publicly funded good.
I think that's right. Yeah, especially with the educational outcomes lagging so significantly there, and then those issues not showing up with other educational institutions, particularly faith-based groups.
All right. Shall we
Well,
move on to the debanking issue to wrap up here?
yes, we'll close with a bang here. This issue um This issue of religious discrimination by private parties is one that's been of particular interest to us here at Napa Legal, and I think it's really worth reflecting on. And there are some delicate issues here because obviously, when you have a state action and a person of faith or an organization of faith, and there's a tension there on religious freedom matter, there's kind of that falls clearly into the First Amendment's and Religious Freedom Restoration Act realm. But what about when a private party, particularly a large corporation, is systematically engaging in or allegedly engaging in discrimination based on religious views or cultural, political, societal opinions? This is something Napa Legal has looked into. Back in 2021, 2022, we issued a report outlining how corporate America was deplatforming religious organizations at a rate of about one per week. And that story was covered quite widely. The Wall Street Journal released the story with an exclusive, and it was covered in a number of outlets afterwards. And then related plans and toolkits that we put together related to deplatforming ended up having a spike in usage after Dobbs when we saw a lot of pro-life resource centers being targeted by private private service and goods providers. Um, so as we looked at this issue, we wanted to understand what had happened and why. So we looked at the justifications of the deplatformings, and the companies that engaged in these deplatformings typically pointed to violations or alleged violations of the company's acceptable use policies or codes of user conduct. And although the deplatforming slowed a bit after the report, correlation or causation, sometimes we like to think causation, corporate America continued to engage in viewpoint discrimination in other ways. And we saw this in the Holy Sexuality versus Asana case that we discussed a couple weeks ago. Basically, no religious groups need apply in some of these situations. So groups, and particularly ADF, led the charge rating workplace discrimination on the basis of religion or viewpoint. And things seemed a little bit hopeless. The early results were quite negative. I think the highest scores were still below 30% on a scale of 0 to 100. But ultimately, through conversations and an exchange of emails, shareholder resolutions, Chase revisited their code of conduct last week. In the new language, I'll read it specifically, updates the code of conduct to say, we do not tolerate discrimination, harassment, or inappropriate or abusive conduct by or against employees, customers, suppliers, contractors based on, and it includes now, religion, religious affiliation, or religious views, as well as political opinions, speech, or affiliations, or any other status protected under applicable law. So, how did this come about? I think it's really important to know. This was done in response to a shareholder resolution requesting transparency and requesting a revisiting of the faith-based employee resource groups available, and then the way the code of conduct was affecting them. So there are a couple things I think we can learn from this. One is there was a lot of hard work that was done here. This was a multi-year, multi-pronged effort that involved dialogue from the public sector, a lot of media coverage and reporting, education of the public on this. There was not really a lot of litigation specifically in this case. Well, in this case, there was no litigation. And so I think it's a great example of showing kind of like the delicacy of addressing these issues in the private sector. Sometimes the First Amendment, it does not apply. There's not state action. Some civil rights laws might apply, and in states like Utah, there might even be a RFRA that applies. But at the same time, just because something's not illegal doesn't mean it's right. And so what these companies do when they deplatform religious groups based on their belief systems, maybe it's not illegal in some cases. I think sometimes it is, but maybe it's some cases it's not. But that doesn't make it right. And I think it's really important for people who are friends of religious freedom to not only look at opportunities for litigation, but also to look at other ways, other forms of advocacy, like ADF has done here, just playing the long game, facilitating these conversations. And I also want to note this comes on the heel of a February victory with PepsiCo that similarly revisited and uh, established policies protecting religion along with other classes. So, in a way, I think some of these are a little bit bittersweet in that not discriminating or not displatforming people based on their religious beliefs shouldn't be like a huge ask, but it's still an important victory. And I also want to draw attention to Ambassador Sam Brownback's um, recent op-ed. He discusses this and his own experience when the National Council for Religious Freedom was debanked by Chase. with no explanation and then conflicting explanations afterwards. So this is a victory, and I think it teaches us a lot. It's a good sign, but also a sign that we need to keep doing this work, and that we need to remember as well that religious freedom advocacy, involves litigation. It involves, even in some cases, lobbying, but it also involves conversation. And just because litigation is not available doesn't mean that there isn't and shouldn't be action taken to protect religious freedom, um, for everyone everywhere, as our friends at Beckett would say.
Yeah, this is a great it's a victory, and it's one of those, I think, similar to what we were just saying with the school choice issues. I think it's important to watch what happens next, right? Because just as there were anti-school choice laws, right, that were excluding religion explicitly, and then that was getting struck down, and so they kind of tweaked it and said, well, okay, it's not based on religion, it's based on your non-discrimination policy. I think it's just worth watching this as, it became very big in the media, and it was clear that the banks were discriminating based on religious beliefs. So I think it'll just be important to watch. They've changed the policy. That's a great victory. And we just want to keep an eye on if organizations are still being mysteriously, inexplicably deplatformed, and if it seems like now they can't do that based on religion, but hopefully there won't be another grounds that ends up causing the same result. So we're hopeful, but I think it's always really important to keep vigilant, because usually when one thing is struck down or defeated or goes away, something else can creep in. So I hate to be the pessimist to end here, but I think it's always important to be watching. All right. And with that, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content that we're putting out, we'd appreciate it if you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations.
Thank you for your time, and we will talk to you next week. God bless.